Hello, Dr. Liddell and class. I'd like to personally welcome you all to the automobile manufacturing presentation. The automobile manufacturing industry has two different associations. The Alliance of Automobile Manufacturers, or Auto Alliance for short, and the Alliance of International Automobile Manufacturers, or AIAM abbreviated. Auto Alliance is the auto manufacturer's voice for the United States and is made up of 12 different vehicle manufacturers including Ford, Mazda, and Toyota, to name a few. AIAM has been around since 1961 and is the equivalent of Auto Alliance on an international scale. AIAM also represents 15 vehicle manufacturers. So how many of you have ever purchased a car? I venture to say a large percentage, right? And what were the concerns or issues you faced while making that decision? I made a list that might look similar to yours. Fuel efficiency is very important, especially with current gas prices, right? Maybe even number one. What about safety and reliability? Everyone demands the reassurance of safety and reliability. Environmentally friendly options such as hybrids or battery-operated vehicles, those are important too. And lastly, warranties and repair. How much is it going to cost you to maintain your vehicle in today's economy? All of these are important issues for consumers and become liabilities for auto manufacturers as presented by Tanisha in Tokyo's air pollution case.
Thanks, Leslie. My case was a Tokyo air pollution lawsuit. It lasted from 1996 to 2007 and involved 633 plaintiffs citing asthma from pollution caused by defendants you see listed below. As you can tell, my case has to do with environmental law. What is it, you ask? Well, it's a body of state and federal statutes intended to protect the environment, wildlife, prevent pollution, and save endangered species, among other things. If you're a fan of breathing easy and enjoying nature at its finest, this should be important. We'll go over a background of environmental law in Japan. Japan has a long history of pollution-related court cases. In 1973, the PRHDC law was enacted. The law was intended to provide prompt and just compensation for pollution victims. It designated two types of areas of compensation. We'll focus on Class 1 areas. These areas were areas where severe air pollution occurred and many people suffered from respiratory disease. However, in 1987, this Class 1 designation was removed, and we'll see why this is important on the next slide. Well, what did this mean? Well, with the removal of the Class 1 designation, a wave of lawsuits ensued. No company too big or too small was safe from lawsuits. Everyone you could think of had been sued. Steel companies, to glass companies, to even the state. This is where my case comes in. Everyone had been sued up until this point except for, that's right, you guessed it, auto manufacturers. And after 11 years, the judge finally said, hey, automakers, why don't you just settle? And they did. The automakers paid 1.2 billion yen as settlement money, even though they were the only defendants not to have shown a causal effect on asthma. But this was also a win in their book. They were able to check off that social responsibility block and look good in the eyes of the community. Also a plus in this case, the Tokyo Metropolitan Government established a healthcare subsidy program, which the automakers, the state, and the MEPC contributed to, as well as took measures to improve the road environment and control vehicle emissions. As mentioned before, there were a lot of court cases involving air pollution victims in the past. They all had two goals in common: medical care for the victims and vehicle emissions control. And as mentioned on the last slide, those goals were met. However, some other unexpected outcomes occurred. The government and private sector records, which were once private, were made transparent for the public. Also, more citizen participation was encouraged with the creation of nonprofit organizations. As well as in 1997, an EIA law was passed and provided a significant avenue for public input into national environmental policy. Enacted after more than 30 years of debate, an EIA is now required for large projects such as construction of roads, railways, dams, airports, and industrial complexes. Here are some ethical questions to ponder. Question number 1 pretty much says, hey, automakers, if you had higher vehicle standards in other countries, why not in Japan where they had a pollution problem? It would have made a lot of sense to at least begin talks of changing vehicle emission standards with the government and look at joint funding options to do so. Probably would have saved them a lot of time and money in court. Question number 2. The government awarded the citizens a lot of money in multiple court cases, but did it do any good if they did not change the standards of vehicle emissions? Well, no, they were basically throwing away money without changing anything. The car companies needed to look at not only how to make money, but how to make the environment better, even if it meant thinking differently from the culture they were in. And the government needed to look at changing standards instead of just awarding compensation. Next we have Jen with the case involving Toyota vehicles.
Okay, Tanisha, we'll now move into our second case study, and this is regarding the unintended acceleration issue faced by Toyota over the recent years. There's been lots of media attention, so I'm sure most of you have heard about it, but we'll talk about what caused those today, and you help decide, did Toyota handle this in the most responsibly way? The results from this unintended acceleration issue, there's been at least 34 reported deaths. Some say that number may rise to as many as 100 before it's all over. Deaths arising from Toyota or Lexus vehicles where the cars had this sudden acceleration issue. There have been at least 10 million vehicles recalled. This is the most expensive automobile recall in history. After a congressional investigation into what may be causing this, Toyota did admit that they had received close to 38,000 consumer complaints regarding the matter. Toyota's been charged a civil penalty for failure to inform timely some of their findings to the NHTSA. There's been at least one lawsuit decided on the economic losses that we'll talk about today. What caused the Toyota car to accelerate unintended by the driver? Toyota first reported to the consumers that it was caused by floor mats not being installed properly, and they did notify consumers and offer to fix those through warranties and did recalls to correct them. That didn't seem to really fix the issue. Toyota then, years later, notified their distributors that there was a sticky accelerator pedal that was causing the problems, and that really never proved to also fix the issue. Eventually, Toyota added a brake override system as standard in their model starting in 2011. They said it was a confidence booster for the public, but was it that, or was it maybe a correction to the electronic throttling system? An electronic throttling system was installed in Toyota cars starting in 2002. Soon after is when the acceleration issues began to occur. The difference between a manual and electronic throttling system: manuals consist of a cable that connects the accelerator pedal to the engine. Electronic, though, uses sensors from the pedal that carries the signal to the engine control computer and then transmits it to the throttle. Other manufacturers, when they install this technology, put in fail-safe mechanisms for when there are failures with the electronic system. Toyota didn't choose to do. The case we're talking about today was a case on economic loss damages, or economic loss. There was many plaintiffs and lawyers consolidated into this case. The case was held in the United States District Court for the Central District of California. It was heard and decided in November 2010. The plaintiffs in this case alleged breach of contract, common law warranty, fraud by concealment, unjust enrichment, and damages for the loss of the market value of their vehicles. Toyota was once known for their high quality, and there seems to be a diminishing impact. The court, though, in their ruling, really favored more on the side of the defendant in this case. They seem to believe that Toyota appropriately handled their responsibilities in providing the recalls and doing the warranties. They segregated the plaintiffs who didn't seek the repairs that Toyota offered. And then the other, as you'll see listed here, some of the other motions to dismiss were also granted on behalf of the defendant. The real question for us today is, did Toyota handle this issue in an ethical manner? Did they do the recalls and warranties timely? Did it address the real issue? Did Toyota have reason to know that the electronic throttling system may be causing this acceleration? And why didn't they install a braking system earlier? It also begs the question, were one group of stakeholders favored over the other? Or maybe did the Toyota executives leave their ethical standards at home?
Thank you, Jennifer. Case Study 3, Williamson vs. Mazda. Seatbelts should be worn. They're one of the most common safety devices for transportation out there. Seatbelts are known to save lives. There are even laws that mandate the use of seatbelts and how they are designed by auto manufacturers. In this case study, we will look at how Mazda Motor of America became held liable for the wrongful death of Thon Williamson. Thon Williamson was killed in a 1993 Mazda minivan, such as the one shown here. Federal Motor Vehicle Safety Standard 208 states that a middle rear passenger seat can be equipped with either a lap belt or a lap and shoulder seat belt system. When the Williamsons' vehicle was involved in a head-on collision, Thon Williamson was the only passenger killed, and the only passenger wearing a lap belt. Witnesses said the lap belt acted like a jackknife, and Thon's body suffered abdominal injuries and internal bleeding. Thon wore a seatbelt. She followed safety rules. Should Mazda then be held liable for damages for not putting in a lap and shoulder system? Let's have the courts decide. Summary of the case. Federal Motor Vehicle Safety Standard 208 states that a vehicle can either use a lap belt or a combination shoulder lap belt in the middle back seat of a vehicle. This gave auto manufacturers like Mazda an option. In 1993, Mazda chose the cheaper, easier designed lap belt to put in its middle back seat of its minivan MPV, which they called multi-purpose vehicle. This federal regulation does not exempt Mazda from liability at common law. The courts started in the Supreme Court of California. It then went to California Court of Appeal. Both California courts agreed that Mazda could not be held liable for the charges being pressed by the Williamsons. The Supreme Court of the United States, however, ruled differently and returned the case to California Court of Appeal. The Supreme Court of the United States is saying that the Williamsons had the right to hold Mazda liable and has returned to the Court of Appeal of California. However, in a similar court case of Guerre versus America Honda, the court did not allow the plaintiff to sue because the automobile safety standard preempted a stricter state rule. What makes the Williamson versus Mazda case different is that there was an option of putting in either a lap belt or a lap shoulder belt. In the Guerre versus American Honda, it said it needed to have an airbag. It did not give a choice of different airbags, such as this case with our seatbelts. Given the option and the stricter state tort law, Mazda should have put in the lap shoulder seatbelt and should be held liable for not doing so. Mazda Ethics. Mazda did follow the federal law. Mazda installed a seatbelt, though, knowing it was the least safe of the two options they had. The lack of safety in the lap belt caused the death of Thon Williamson. Mazda chose the cheaper seatbelt with less additional design required. So does this make Mazda an unethical company? The car could have been built safer by including a shoulder lap belt in the middle of the back seat. Therefore, the most ethical choice would have been to put the seatbelt with the highest level of safety in the car, thus keeping the consumers from harm. In this case, it appears that Mazda Motor Company favored their shareholders and employees over their consumers. They chose to reduce the work time, effort, and cost to satisfy shareholders and employees, but inadvertently affected the consumer by producing a car with a seatbelt that was less safe than a more expensive, complex option they were aware of. In my personal opinion, I do not think the CEO of Mazda set out to kill people by putting in lap belts. He decided to abide by federal law and chose the cheaper design to save money and also for convenience of access and egress to the back seat. Things can always be built safer. There's always going to be better. So at what point are we really accepting the risk? We have to be willing to accept some kind of risk at some point. This is why I feel that Mazda still made an ethical decision, although maybe some parts could be better. I'll let you decide. I would now like to turn it back over to Leslie to share our comparative analysis and wrap the presentation up.
Thank you, Tanisha, Jennifer, and Justin. In closing, I'd like to address a few things. Whether it's air pollution, sticky accelerator pedals, or lap shoulder seat belts, the auto manufacturers need to be striving above the industry standards as presented in the cases, because it is simply not enough when lives are at stake. I would also like for you to remember the consumer issues presented at the beginning of this presentation. Yesterday I paid $4.25 for a gallon of unleaded gas. Fuel efficiency really matters. Thank you for listening to our presentation.